Is parody considered trademark dilution under the law? Imagine seeing a funny cartoon that makes fun of a popular brand. You might wonder if that kind of humor could hurt the brand's reputation or weaken its uniqueness. Today, we're going to explore whether parody counts as trademark dilution under the law. Trademark dilution happens when a famous brand's unique image or reputation gets weaker. This can happen through blurring, which makes the mark less distinct, or tarnishment, which harms its reputation. The goal of dilution law is to protect these well-known marks from uses that diminish their power, even if no one gets confused about who made the product. Now, parody is a form of humor or satire that uses a trademark to comment on or criticize the original. Courts recognize parody as a protected form of speech under the First Amendment. Because of this, parody usually isn't considered trademark dilution. The law sees parody as a way to express opinions or make jokes, not as a way to compete or confuse consumers. The Trademark Dilution Revision Act of 2006 explicitly states that parody is a fair use and cannot be used to claim dilution. But there are some rules. The parody must clearly transform the original mark. It should add new elements that show it's a joke or critique, not just a copy. If the use is purely as a trademark to identify a product, it might not be protected and could be considered dilution or infringement. Courts also look at whether the parody might cause confusion or harm the brand's reputation. If the parody is obvious and clearly humorous or critical, it usually avoids legal trouble. But if it looks like the original or tries to pass itself off as the brand, it could be seen as damaging or diluting the mark. In the end, parody is generally safe from dilution claims if it meets these conditions. It must be recognizable as a joke or critique, not a competing product. Trademark owners can't easily win a dilution case against parody that follows these rules. This balance helps protect free speech while respecting trademark rights. So, in most cases, parody isn't considered trademark dilution under the law, as long as it's done thoughtfully and clearly as a form of expression.